Hi there. Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. Today I wanted to continue on our theme of common misconceptions when seeking to apply for Medicaid. Another common misconception that I frequently hear in my office is that their mom or dad or their loved one has no assets because all of the bank accounts in which their monies are held are joint accounts with them or with a sibling or some other relative. So they commonly think that because all funds are held in a joint bank account, that clearly they're just going to claim that it's the well person's monies and it's not their elderly loved one's monies, and therefore they're going to ease through the whole Medicaid application process because they're just going to tell the government that those monies are really, Bobby Sue's money and not grandma's money. This is a common misconception because Medicaid treats joint accounts as if it is the applicant's assets. It is very common for people as they age to add another person onto their bank accounts for ease of banking. Somebody else helps them out pay their bills, things of that nature. And many times accounts are held jointly. And it's Medicaid's position that those amounts and the funds in those joint accounts are counted as assets of the applicant unless you're able to otherwise prove that it is not the applicant's assets. So the presumption is that it is the applicant's assets, and therefore just by simply throwing your name on their bank account is not a planning mechanism in which you can then claim that all amounts in those joint accounts are not the Medicaid applicant's monies. You have to go through a tested procedure to be able to establish that indeed those monies are not the applicant's funds, although they're in a joint account. They belong to somebody else who's not applying for Medicaid. And once that's established, then of course those assets would not count. However, the presumption is that all amounts in joint accounts are the Medicaid applicant's funds. So that's a common misconception that people I hear in my office where they say, oh, don't worry about the Bank of America account or the Chase account or the PNC or you name it, whatever branch that they may bank at. Don't worry about that account because so-and-so's name's on it as well, and that's their money, that's not the applicant's money. And so then that's normally when we have to have a conversation about how the Medicaid office is going to be viewing that, and then we talk about how we're going to prove that indeed that's not the applicant's monies. All Medicaid applications and plans are unique. Each person has a unique financial history, unique finances, unique health reasons. They are all different ages, different walks of life, and different goals. So I really encourage you, if you are looking into engaging in Medicaid planning, to reach out to an elder law attorney to assist and walk you through this process. It is invaluable to have a guide that could help you make wise decisions so that way your application can be as smooth as possible. We are dealing with government entities and rules and red tape at times that can be frustrating to people. So while we like to make every application as seamless as possible, the reality is sometimes there's bumps along the way, and it's really good to make sure that you have on your team counsel that can help walk you through it. I hope that this information has been helpful to you. Feel free to like and share with those in your community that you think may benefit from this information, and I appreciate you joining me. Thank you.